birthday, Michael.
You have one more in the waiting room.
I do.
Can't do this in German.
You're up, Michael.
You can go
You're
ahead.
on. No. I'm supposed to talk right now. Hello, everyone. Welcome to the presentation on guardianship and protective placement. I am Mike Fugel. I'm drinking water, so I took off my mask. Beth Herkler is also here. And
Morning.
so the goal here is to provide you all with an overview of what social services does and what social services needs in terms of having pursuing a guardianship and protective placement. None of what I say today should be construed as legal advice. I do not represent any of you. I represent Oneida County. So if you have questions about this, you should certainly talk to your legal counsel. But I'm sharing with you from the perspective of Oneida County, kind of where we are. So let's get started.
And just so you're aware, we're going to tape this and we'll send it all out to everybody who's participating or who I have emails for. So if you have new staff, if you want a refresher, if you have questions, you can go back to this presentation later. We will also save it here. So if for some reason it gets lost or you can't find it, you can contact us and we'll send it out to you again.
For those of you that aren't the olds, tape means record.
And if you have questions, I believe there's a chat box. You can type them into the chat box or unmute yourself and ask questions. Carrie's giving me a frightened look. Hopefully we have a chat box.
So we're getting this figured out, kind of maybe as you are too. So I apologize for any delays. I'm not the most technologically adept, so sorry if there are delays or hitches. If you do have questions, please ask them as we go through. I hate saving my questions to the end because I always forget what I wanted to ask. But so our first slide, preliminary considerations. This is the question of, is a referral to social services necessary? Kind of the primary question is the individual in question, the proposed ward, would they be able to execute a healthcare power of attorney? In most instances, a healthcare power of attorney is going to be sufficient to accomplish everything that needs to be accomplished. Healthcare power of attorney allows the power of attorney to make decisions if the person is incapacitated. It will allow the POA to consent to medical treatment, will allow the POA to sign releases, will allow the POA to check the person in if the document specifies to a nursing home or recuperative care facility and that type of thing. About the only thing a healthcare power of attorney cannot do, and something that a guardian cannot do either, is consent to checking someone to an inpatient psychiatric treatment facility. So, an interim step of having a healthcare power of attorney is always preferred. And one of the reasons is that presumably before executing the power of attorney, the person has talked to their POA and explained to them what they want from, in terms of medical treatment. Do they want every measure taken in order to extend their life, or is their primary concern to not be in pain? So, and just for all of you, if you don't have a power of attorney, it is something that you really ought to consider, because To be blunt, when you're in a car accident and you're unconscious, you're not going to be able to do a POA at that point, and you may wish that you had. So prior to making a referral for a guardianship and protective placement, and I guess I should differentiate between the two. Guardianship is appointing someone to be a decision maker for the person, meaning healthcare, healthcare decisions, those types of things, and the estate, which is the financial decisions. And those are also two separate powers of attorney: healthcare power of attorney for healthcare, durable power of attorney for pretty much everything else. So there is in Wisconsin law provides, as I understand, a supportive decision-making option. And that is an option for someone who may not be incompetent. They may be incompetent as well, but they may not be. But they need someone to assist them. And they can identify a friend or family member to help them to process information and to make decisions, but retain a greater measure of freedom. At the bottom is a website address they have some training materials there regarding supportive decision making. And in any event, before social services will file a guardianship petition, they'll be asking the questions about supportive decision making as well. So if that is something that you social workers who are on the front lines are able to do, that may mitigate the need for guardianship, and that may provide for the individual's wishes to be carried out in the manner that they would like. Click.
Right.
That was good. So jurisdiction and venue. Jurisdiction refers to what court, what county circuit court will decide a guardianship case. All guardianship and protective placement cases are decided in the probate court. In Oneida County and in the 3-county area, we have 1 or 2 judges, and so each judge hears civil cases, probate cases, children's cases, family cases, criminal cases. In larger counties, they may have a court, a branch of the court that is assigned to only do probate cases for that year, for that period of time. So then there is venue. So jurisdiction is, can a court hear the case? And venue refers to what county should the petition be filed in. And so the preference is the county of residence of the proposed ward, because that for the person will be receiving services, presumably. If they return home, that's where the assistance would go to. The county in which the proposed ward is physically present is also an option, but the best referral is to the county where the ward lives, because that is the county that will be able to follow through best. So, guardianship, Chapter 54. This applies to people who are incompetent. The incompetency has to be permanent or likely to be permanent. And there are 4 areas: developmental disability, serious and persistent mental illness, degenerative brain disorder, and then kind of the catch-all, or where it's hard to differentiate maybe whether it's mental illness or dementia or something along those lines, other like incapacity. Then the next step is that the person is unable to make the necessary decisions, and that regards their personal welfare or the guardian of the person, Can they consent to medical treatment? Where should they live? Can they get a fishing license? Those are all personal welfare guardianship of the person issues. And then finances or person of the estate. One thing you know about person of the estate, guardian of the estate, wrote this. Financially, an important thing to note for if someone is the guardian of the estate, they are required to file an annual report with the circuit court. And that can be a hang up for some people. Some people aren't good with paperwork, some people don't like to follow through, but that is something that is necessary. The courts get a little cranky when they aren't filed in a timely manner, and the guardian will get some letters which will become more and more strongly worded and eventually may result in the court requiring the guardian to appear in court, and could involve the court removing the guardian if they're not filing these annual or yearly reports. So how do guardianship cases start? Well, oftentimes it's a referral from a hospital social worker, a social worker at a facility where the person is residing, or another concerned person. So HIPAA does not apply to this referral. So, because if it did, you wouldn't be able to make the referral. And I've added the statutory language there. It does cover the elder at risk agency receiving the appropriate information in order to be able to proceed with doing an investigation and filing the petition. 14682 2A7 is the statutory site, and that is and that relates to providing information without the informed consent of the individual. So if someone is in a coma in your facility and they need to have someone appointed to make decisions, HIPAA doesn't apply to you sharing the information that they're in your facility, they're in a coma, and then the other information related to the referral. So the elder at risk agency, social services, can proceed with this. And again, it's laid out that the provider may release the information by initiating contact. You don't have to wait for a call from social services. One of the important components, one of the necessary components, is that either a physician or a psychologist has to complete a report regarding the ward's condition. There is a circuit court form. It's the GN 3130 form. The form, most physicians and psychologists should be at least familiar with it. It's very straightforward in terms of, if they look at the form, they're checking boxes and they're providing additional information. And it's important that they don't just check the boxes that someone's, that someone has a moderate impairment of their executive functioning. It's very helpful, and the courts find necessary to have at least some information on, how that determination is made. Does the person need to be prompted in their activities of daily living, or are they incapable of performing them at all without someone actually assisting them to do so? So, there are check boxes. There are also lines for a description, and we encourage physicians and psychologists to add the description, because oftentimes that is a determining factor in as to whether the physician's or psychologist's testimony will be necessary, or if the court will just receive the report. So it's going to, one part of it is the condition permanent or likely to be permanent? If it's unclear, they should state so, in which case we can ask for a temporary guardianship and then reassess the person as they either improve or decline. Each of the rights are spelled out and should be indicated what rights should be removed. If someone is unconscious, there's a big chunk of the report that doesn't have to be completed. There's just, yes, they are unconscious, and so they're presumed to be incompetent. And then finally, we get to whether the person requires protective placement or protective services. And those either protective placement is the court orders someone to be in a specific type of facility, or orders specific services to be provided to the individual. If the ward's condition changes, it's important to update the report, and that can either be the writing a letter saying, look, when I saw them, this was their condition, and this is where they are now. And so, and again, if they've explained, provide a description of what the infirmities and such are, the follow-up letter is easier, or they can just complete a new report. But in any event, you know, if the person recovers, then a letter saying, hey, they're competent is sufficient, signed by the physician. If they decline and there are further considerations that need to be made, or maybe they now need protective placement, then the report should really be updated. We covered this a little bit, but prior to making a referral, it's important to ask a family member if the person has a healthcare power of attorney or a durable power of attorney, because either of those are, if executed, that's what the proposed ward, the person who's in crisis, that's what they really wanted to have happen. And so it's important that we give great deference to that. In addition, in terms of referral, it's important to get information on the interested persons, next of kin and adult relatives. Because if we just get Bob Smith, who lives in Minocqua, one of the, in terms of filing a petition, we have to notify all the adult relatives. And so often the facility, well, not often, the facility making a referral is going to have better access to that information than social services in terms of tracking that down. So please include that as well. Provide information such as you have it regarding their finances and especially any insurance they have. Provide the ward's current address and how long they've been living there. And then any initial and updates regarding the discharge planning so we can make that determination. Social services files guardianships and protective placements, but the proposed ward must qualify for the services. There are asset limits, and folks have to be indigent. We have had to, in the past, not provide services because the person had significant cash on their person at the time, and so they did not qualify for assistance by social services. Additionally, and this is also provided, but for Oneida County, we file petitions if they're a resident of Oneida County. If they're not a resident of Oneida County, our Department of Social Services would then want that referred to the county resident who's going to be able to provide greater continuity of services for the individual.
Can I ask a question on asset limit?
No.
So if, I know we've done a few where a person is on MA, but they have a special needs trust with thousands of dollars. So can that special needs trust be used to have an attorney do a guardianship, or would we do it anyway? We usually find it out after we've already started the process.
It depends on what the trust says.
Okay.
So, but that is something that would be a consideration, yes.
Okay.
So, in terms of filing guardianship cases, it's important to figure out who is going to serve as the guardian. Family members are typically the first option. Presumably, they have a relationship with the person. You know, just because someone's child appears to be a lush doesn't mean they're not appropriate to be a guardian. I mean, everyone has flaws. Yeah, I know, especially me, Gene. Thank you. So, you know, just because someone has flaws doesn't mean they're inappropriate. Now, their flaws may be glaring and they may be inappropriate, but we shouldn't necessarily rule people out merely because, you know, they've got some wrinkles that that we all may have. Yes, me, Gene. One thing that's very helpful is to ask family members if they all agree on who should be the guardian. If there's going to be, you know, if you've got 5 siblings, or, you know, if you've got 5 possible guardians and each one of them thinks that they're the best and that the others shouldn't be because whatever reason, then that's when we look to is a corporate guardian or a disinterested third party more appropriate. And just know, I mean, courts prefer family members, but you know, certainly there are family members who just, I mean, they're not responsible for their own lives. So, and you're appointing a guardianship of the person in the estate. It doesn't have to be the same person for both. And there are times where a family member is appointed guardian of the person, and a corporate guardian is appointed guardian of the estate, and that makes it cleaner for everyone. So now there are, if the person does have a power of attorney, and there's a referral, it's tough to convince a court to remove power of attorney. And the reason for that is that there's a presumption that power of attorney is acting in the best interest of the ward, is doing what the incompetent person wanted to have done. You know, that's the person that the now incompetent person chose to make decisions for them down the road. So we've had some referrals that are difficult because it's felt that, well, you know, the healthcare power of attorney isn't doing what's best for the person. You know, but there are there's a wide range of acceptable behavior for a POA, and the power of attorney, their duty is not to really anyone else other than the person they're power of attorney for. So, and that can create conflict. And if they have a valid power of attorney, the courts are gonna look very carefully, and they're gonna want some substantial evidence that the power of attorney really isn't doing their job as it was. I think I covered. So we don't have to have the same person do person in the state. Who wrote this anyway? Goodness gracious. Doesn't make any sense to me. Does anyone have any questions so far? Take that as enough. So, and I alluded to this earlier, is it necessary to appoint a temporary guardian? And a temporary guardian will be appointed when there are decisions that need to be made immediately. Does someone need to consent to medical procedures while the person is incompetent? A temporary guardianship petition, the hearing can be within 48 hours of filing the petition. In a normal guardianship, in a regular guardianship, permanent, we typically don't have a hearing in under 30 days, and it's usually around 45 days from the date of filing. So if there's an emergency, that should be flagged and we can get that in. The temporary guardianship is good for 60 days, and it can be extended for an additional 60. But in this little bit of a quirk in the statute, if a petition is filed for permanent guardianship, the hearing on the permanent guardianship has to be within 90 days of filing. So we will, on many occasions, file a petition for temporary and for permanent at the same time. So really, we have to have that final hearing within 90 days. So in the temporary guardianship is useful in terms of someone is unconscious, but they're expected to recover. And so, we'll file the temporary and kind of, ride it out and see where we get from there. So once the petition is filed, the court will appoint a guardian litem. Guardian litem in Wisconsin, they are an attorney. They represent the best interest of the ward. They certainly listen to what the ward wants. Sometimes that aligns with what they're doing, but ultimately they are going to do what the ward needs. They're going to do what's in the best interest. So, some wards, they're like, well, I don't want anyone to be my guardian, and this is stupid. And if they fit the bill, then they're going to end up with a guardian. So the guardian litem is independent from the petitioner, from whoever files the petition requesting guardianship. They're going to do an independent investigation regarding the proposed guardians, get information about the ward, that sort of stuff. And they're going to make a recommendation to the court, including what rights should be removed. Well, first, should there be a guardianship? And then what rights should be removed, and also the suitability of the proposed guardians. So if there's not a stipulation, the physician or a psychologist will be required to testify at the hearing. And oftentimes that stipulation happens the day before or the day of the hearing, which I know gets doctors and psychologists a little bit cranky, but the guardian litem is supposed to meet with the ward close to the date of the final hearing, so that doesn't always shake out in the time frame that a doctor might like to shake out in. A physician or psychologist may say the ward shouldn't attend the hearing. Generally, a guardian litem will defer to that determination, but ultimately, if the subject is going to be, if their appearance is going to be waived, it would be because the guardian litem waives it. Hearings are not open to the public, and there is no right to have an attorney appointed to represent the proposed ward unless there's also a petition for protective placement. And the reason for that is a protective placement, you're restraining someone's liberty, telling them where they have to live, and so they get to have, they get counsel. So after a guardian is appointed, if there are allegations of misconduct, someone may file to review the conduct of the guardian, have the guardian removed. Social services and Oneida County will stay involved in terms of locating service providers and placements. Also, if the person is still at the facility, discharge planning and that will assist in the same way. Social services will assist in locating funding resources. And the people from family care are like, yeah, you just send them to us, but that's not completely true. We send them to the RDC too. If, and it has happened, if the ward was incompetent and they get better, if they become competent, there can also be a petition to dismiss the guardianship because we shouldn't have a guardianship on people who are competent. And then now, if the ward is so incapable of providing for their care, such as to create a substantial risk of serious harm to themselves or others, then protective placement may be an option. So for there to be a protective placement, first, the person has to be a proper subject for guardianship. And the protective placement can be filed at the same time as guardianship, but there needs to be a belief that they are the proper subject. They need to have a primary need for residential care and custody. And then there has to be concern that if there isn't protective placement, that they're going to come to serious harm or harm others. So in the Guardianship 3130 report, there's a section that the psychologist or doctor will fill out, which sets forth whether or not the individual is appropriate for protective placement and for what level of protective placement. You know, do they need a locked facility? Do they need, because they're a risk, there's a risk of elopement? Do they need a nursing level of care? Do they need to have someone who provides them prompts for their ADLs? Those are the types of things that the doctor can opine about. A social worker at the facility before discharge or in conjunction with social services locates an appropriate facility. Ideally, it's near the guardian and your family. However, there's no prohibition on someone, if the only appropriate facility for the person is in Platteville, then they go to Platteville. Social worker will look in terms of funding sources for payment of placement expenses. Can the person pay themselves? And then there's determinations regarding spousal impoverishment, which I'm sure everyone would like me to talk about, but I'm not going to. Is county money or grant money going to pay for it? And then a shout out to the ADRC and family care, because there are likely referrals made to both of you in that regard. So if the person is in a hospital, they can actually be protectively placed to the hospital if necessary. They can be protectively placed for discharge to a different facility. There are also occasions where there's an acute need for, Social workers go to a house. Oh, someone's chatting.
I'm getting there.
I don't use emojis. Just smiley face.
We'll get to it.
Okay, so we're going to get to the chat in just a moment. So there are times where there is an acute need, an emergent need for an individual to be protectively placed. If this occurs, it's required to have a hearing within 72 hours of detention. And for instance, Thanksgiving is not counted, it's a legal holiday, but the Friday after Thanksgiving is counted. So that can also shorten things up. Go to the top. Control H. So if the individual, okay, so Cecilia has asked, please clarify the social worker responsible for finding funding. Is it the county or the facility? Beth?
It's both, actually. We would make a referral to the ADRC. Certainly, hospitals can make referrals to ADRC so that they can get family care funding. If they're, I mean, we would want to know if they're on MA, if they're going to a nursing home, so all those things would factor in. The quicker we find out about funding, the faster a person gets moved along in the system and gets placed. So anybody can make a referral to the ADRC. So for family care, or, you know, eligible in family care. I don't know if that completely answered the question, but we do have funding available here. If it's an emergency and a person needs to be moved, we have elder abuse funding that we can assist in. Temporarily funding, we have agreements with the ADRC. They have a couple of funding sources that we can utilize in a crisis to move a person either home or to a facility temporarily.
So back to an emergency protective placement. If there's an emergency, an individual can be protectively placed by law enforcement or a social worker. If that happens, we need to get that Guardianship 3130 report completed in time for a hearing, which is 72 hours from the time of detention. As I alluded to earlier, an individual who is being protectively placed is entitled to adversary counsel, and the Public Defender's Office does appoint on all protective placements. So, and again, there are less stipulations in protective placements, but they do occur. Then it would need to be both the guardian ad litem who will be involved and the adversary counsel who would need to agree that the testimony isn't required. Again, the person has to be present unless that is waived. This is not open to the public. Now, so, and then after the person is protectively placed, they can be moved to a different facility at the same level of restrictedness with the consent of the guardian. They could also be stepped down as appropriate. If they are moved to a more restricted placement, that would be reviewed by the court. And again, individuals subject to guardianship cannot be placed in a psychiatric facility, and anyone who is protectively placed has to be the subject of guardianship.
I just wanted to mention with that, if the person gets moved, there's that notice of placement change that
Yes.
we completed.
Yeah, there is a form
Doesn't always happen.
for if the person is moved to notify the court where they're going to be. Now, in terms of protective placement only applies to facilities that are more than 16 beds. So if someone is going to be placed by a guardian, if the facility has less than 16 beds, then that would not require protective placement. So many community-based residential facilities are less than 16 beds, and so there's no need to have protective placement when they're put there. So thank you for coming to my TED Talk. Anyone have any questions, comments, harangues?
Say I think there are probably a few of us. So my question being, like I know with power of attorneys they have it so like with the document you can check off like yes I consent for my agent to admit me to a CBRF. But if I've been told that if the person is still unwilling to go, they can't be like forced to go to a facility, even if it's in their best interest. So I guess my question being like, in that case, like, do we try to move towards guardianship and protective placement, or do we just deal with it? I guess that's my question. Like, what to do when a ward doesn't want to go?
So, and this is a better question for the actual facilities, but there is a procedure whereby if someone does object at a facility, there's a process by which the ombudsman and such can be involved. But it needs to be a specific objection. It can't be like, well, I don't really want to. We've had a number of cases where someone's been like, well, I don't really want to go there, and then they go there, and then
everything's fine.
Then they love it. So there's a not to avoid your question, but there's a delicate balance in terms of when in that situation it would become appropriate to have a protective placement. Because again, and I defer to the folks of the facilities, there's a process where if someone does object to being at that facility, then they go through a process in terms of determining how they have to proceed.
So the chat, if a client needs protective placement because they are an elopement risk but has the means to pay a private attorney for guardianship, who does the guardianship? So the guardianship would be done by a private attorney, and then they would make a referral to our office to complete the protective placement piece of that.
And
there's anything
well, and there is, and we don't do it at the county, but if a hospital has a private attorney do a guardianship, there is a mechanism by which the fees for the guardianship can be reimbursed by the ward's estate.
Did
that answer your question, N/A?
And could we get could we get the PowerPoint presented? Yeah, we will send out the PowerPoint along with the video. So if you want to use this to, like we said, train new staff, if you want to review it because you have a question, whatever. Different counties do guardianship and protective placements a little bit differently. So this is Oneida County version of how we do it. I would suspect that most counties are similar, but there may be things different in Vilas, things different in Forest that are not the same. And I guess N/A, can you tell us more about what part you'd want answered on that question?
This is Cecilia. Can you guys hear me okay?
Yeah, we can hear you.
Hi. I'm trying to remember back to what we were talking about a little bit earlier in the presentation about county of residence being the where we want to start the guardianship if it's appropriate for a county-based guardianship due to the patient being impoverished. What if, and this is one of those one-offs, what if the person is new to our area, very recent, and has an established residence, but does not intend on going back to their location? Would we then be initiating through our county?
Well, I mean, it would,
So
it would depend. I mean, because there are people who are homeless who still have a county of residence somewhere else. But there's also a mechanism for changing venue and that sort of thing. So, I mean, it would really depend on the situation. I'd hate to give a general answer to a question that is very nuanced. So,
I mean, generally speaking, if they have a house or a residence here and they intend to stay here, the residence is here, even if they've only been here a month. I mean, we would obviously point that out in the report that they've only been here a month, but I mean, if their intent was to move here, they bought a house on a lake in Minocqua and they were retiring here, then their residence is here.
then they probably got money to
Right.
get reimbursed.
That's true too.
So this is Cheryl. I apologize, I didn't change my name on there from NA to right away. But the question that I really have is, so we have a patient who comes in, I'm going to give an example. Walking down Highway 47, has no family members, has no ID, is clearly incompetent, and they're obviously an elopement risk. Well, then we find out that they have some financial resources, but they have no one to advocate on their behalf for the guardianship. There's no family members to seek out an attorney or this or that. And again, they need that protected placement. They're chaptered, all of that stuff. How do we proceed with guardianships for that type of a situation?
Well, if they have assets, then make a referral to your legal department, and they could proceed with the guardianship, have a guardian ad litem appointed, and be reimbursed out of the ward's estate.
So that would be the responsibility then of the hospital or care facility that they're at, where they're emergency protectively placed, to pursue the guardianship and their corporation counsel or whatever to pay for that, correct?
Well, if there's an emergency protective placement, then the county is involved. Because, and if we get involved, then we would proceed with it. But, I mean, if they're admitted to the hospital and they get medical care, and all of a sudden, you find out the suitcase they're dragging around is just filled with $100 bills, then that would be the facility making the referral to their local counsel to handle the petition.
Thank
And
you.
then you'd probably be getting a corporate guardian if there was no friends or family available.
Can you talk a little bit about the process as it's ongoing? So somebody is appointed guardian 20 years later, maybe doesn't themselves, is going through some sort of a health issue. What does that look like? Or maybe I get signed up as a guardian, but then 2 years later, I'm the guardian of a state, I stop paying the bills for the member, and now family care, is aware that these bills are not being paid. How would we go about that process?
Then I notify the register and probate, and if they aren't keeping up with their filings, the court would be involved, and there may be a basis to file a petition to review the conduct of the guardian as well.
So for Oneida County, that'd be Amy Franzen that you would contact.
Okay, yeah, and that helps with the financial piece. And then we do have a few where, again, it's just the person themselves, the guardian themselves is aging. They still want to make the decisions for the person, but there's questions about that piece. So I'm assuming, is that Amy as well, or is there somebody else we contact where if it's like the guardian of person issues where they're sort of deferring or not making those sort of decisions for a member?
If it's healthcare, then you would contact our department.
And you can address it with them. Do they still want to be the guardian, or maybe address with them, would they like to resign as guardian? Because then we can do a successor. So, you know, if they're aging or having their own health problems, certainly the case managers can address that with them to see if they still want to be that. Because getting a successor guardian is fairly easy if the person is willing to give it up.
Right. And really all they have to do is send a letter saying, I don't wish to be guardian anymore and I would like a successor guardian appointed. They do have to continue to serve as guardian for that person until a new guardian is appointed though. They can't just send the letter and say, I'm done. They, you know, there's usually takes a couple of weeks to get one in, you know, unless there's some sort of emergent circumstance where we need to get it faster. But otherwise, if they send a letter saying, I don't want to be guardian anymore, you know, it doesn't take us terribly long to find a new one. But we do have to examine again, is there family members that want to now act as guardian, you know, those sorts of things. So if you're aware that, you know, Aunt Betty doesn't want to be guardian anymore, but, you know, Uncle Dean is up for it and, you know, he's ready to go, then that helps us a lot in the process to get a successor guardian appointed.
Yeah, that helps. And I think those are probably the easy ones. It's when the person themselves is not grasping the fact that maybe they're not able to make the decisions. And so they're not interested in stepping down, but then you've got other people who are starting to get concerned with the decision making. So we've had just one or two where, you know, the person still thinks they're in that, maybe they think they're in that role, but they really haven't been able to make decisions. And so just a couple of those.
Yeah, well, and as I'm sure you're aware, a lot of times it helps to get family involved at that point. And, you know, sometimes the kids can talk to the parents and say, hey, maybe this isn't, you know, I'm more than happy to take over for you. Are you ready? You know, I'll still consult you on decisions, that sort of thing. But, you know, we have all sorts of situations, so. What other questions do folks have?
I have one.
All right.
So the guardianship and protective placement, so say someone's placed in a facility, so we know with the protective placement, if they take off, law enforcement can be called. They say, this person's under court order, law enforcement can bring them back. So the power of attorney documents that someone completed while competent, saying this person can place me in a CBRF or nursing home, and they're there, and then they want to take off. I think I've been told different things, but is that power of attorney document, is that where law enforcement could be contacted because that person said the agent could place me?
Well, I think at that point, if they become an elopement risk to a facility that they're placed in pursuant to POA, I think that the facility has a process that they're supposed to follow in terms of attempting to resolve that issue, or ultimately that may then require protective placement.
As a last resort.
You know, and if we have to do protective placement, we can still, in that case, we can still leave the power of attorney in effect and just have it a guardian of the person. But allow the power of attorney for healthcare to make the decisions that they previously made. There's a lot more freedom for a power of attorney to make decisions than for a guardian. So,
I guess I have a question similar to that and also similar to my previous one. Like so the person signs the form saying, yes, you can put me in a facility, currently living in an apartment by themselves, and power of attorney says, okay, you know, it's time to move to the facility. Can they call law enforcement to enforce that person to move if that person like locks the door and says, hell no, I'm not going? Or is it just kind of like, I guess, what do we do in that situation?
I think the power of attorney would probably have to try and coordinate with, I guess power of attorney would have to be more involved. I don't know that law enforcement would directly get involved. unless there was unless there was a welfare check being done. But even then, I don't think you're gonna go over and kick in the person's door and drag them out. They don't have that authority. So, I mean, in that case, probably a welfare check and then escalate from there as
Yeah.
necessary.
If it meets conditions for an emergency chapter 55 placement, I mean, potentially then law enforcement could act if the person's, what is it, imminent danger to
Yep.
self or others, that sort of thing.
Right, because that's what we're trying to avoid is like that escalation, but I don't think in this case it's gonna happen that way.
I mean, we've certainly had those cases when we did cop waiver and it just, I mean, I know they're complicated, but you just have to try different ways and use different skills and try to convince them. I mean, I know there are those ones who are gonna be adamant no matter what, but I guess, we don't want to do a protective placement if it's not necessary.
Another question that comes up a lot for us is, our relative is making horrible decisions. We think they're incompetent. We can't start our process without a physician or a psychologist saying that this person is incompetent. Just saying that they're not competent because of poor decision making isn't enough for us to start a guardianship. So we really need that person in front of a doctor. We have people that are referred to us that have not seen a doctor in 10, 15, 20 years. So like I said, we have to have that examining physician's report for a guardianship. Unless we get into, like I said, a situation where it's a life or death circumstance. And we've had those where we walk in the home and things are so horrible that this person is literally not going to make it unless there's some sort of intervention. You can also always refer to our department for an adult welfare concern. If you have concerns about a person, you're not quite sure it meets, the need for guardianship, or you think there might be something going on because you've seen a significant change in behavior and somebody needs to check into it. We don't do welfare checks, that's the police. So if you think, Joe Smith might have fallen in his home because he's not answering, that's the police, call them. But if you think, Joe Smith's behavior has gotten a little strange lately and he's starting to, potentially have hallucinations or things like that, and we need a plan before it hits crisis, please call our department. Please make a referral for either an adult welfare concern, or if it meets emergent criteria, then we would do it as an adult protective services referral. So we, most of the calls that we get to the agency with concerns, we'll send a worker out, we'll give them resources, we'll check on things, we'll make sure that they have powers of attorney in place, that family members are involved and or aware of what's going on, that sort of thing, and connect them with the ADRC if they need it, to get a referral for family care. So don't be shy about calling us for those types of situations. Yeah, June said thanks a lot. Yeah. Other questions? Okay. Well, like I said, we did record this. We'll send it out to folks. If you have questions on the presentation, please get a hold of our department. And that's all I got for today, folks. Thanks.
Thank you.